Welcome to our webinar. I am Vicky Neznansky. I'm a Chief Development and Social Services Officer at the YM and YWH of Washington Heights and Inwood. It's a pleasure to welcome you all to our webinar on housing challenges during the COVID-19 crisis. Thank you very much for Magda Rosa-Rios, Acting Attorney in Charge, and Edda Santiago, Staff Attorney at the Legal Aid Society's Harlem Community Law Office, for speaking with us today on this very important topic. Since the onset of the coronavirus outbreak, we had provided Y program members and the public with fun, meaningful, and inspiring online events. We will continue to do so while New York remains on pause. Check out the menu of all the events at our ywash.org/home. You can find us as ywashhds.org and then look for a lot of our programs. We also, please note that we are also offering assistance for those who, emergency assistance for those who lost their jobs due to coronavirus. So please check the same website at ywashhds.org. Please note that we're recording this webinar, and now I'm very happy and privileged to turn this presentation to Magda. Thank you, Magda.
Magda, you're muted. You have to unmute yourself.
Thank you, and good evening to everybody. As Victoria stated, my name is Magda Rosa-Rios. I'm the Acting Attorney in Charge of the Harlem Community Law Office of the Legal Aid Society, and I'm also the Director of our Housing Justice Unit Group Advocacy. The Legal Aid Society, for those that are not familiar, is the oldest and the largest provider of free legal services to low-income people in New York City. We've been in existence for, I think now it's about 120 years. We are divided into 3 different practice areas. Probably the most well-known is our criminal practice, where we provide representation to people that are accused of crimes. But we also have a juvenile practice and we are the largest defender of children in the city of New York. And Edda and I are part of our civil practice. Edda and I are actually both housing attorneys within the civil practice. But within the civil practice, it's everything else that is not criminal or it's not juvenile. So we have an immigration unit, an employment law unit, a benefits unit, housing unit, as I mentioned. We have a tax law unit. We represent small businesses and nonprofit organizations. We represent people that are HIV, have HIV/AIDS or are HIV positive. We have a consumer law unit. We have a health law unit. Just about anything that a New Yorker needs in terms of services, we have a unit that can provide that. During this horrible pandemic, people are gonna have a lot of questions about benefits, about health, about what things they can do and what rights they have. And we are lucky that the Legal Aid Society is here, that we have continued to work remotely as most other organizations. We've continued to work, we continue to provide services, we continue to fight for the rights of New Yorkers. So I'm going to turn it over to Edda now to start our presentation on housing rights.
Thank you. As Victoria mentioned, my name is Edda Santiago. I use she, her pronouns. So I'm a staff attorney at the Harlem office of the Legal Aid Society, where I practice in the Tenants Defense Unit housing practice. I'm also a resident of Washington Heights and actually live just a few blocks from the Y. So I was very excited to have this opportunity to be part of this webinar for our community. Before we get started, I just want to outline 2 important disclaimers. The first one is that this webinar is intended for informational purposes only, is not specifically tailored to anyone's specific legal needs regarding their situation. Information shared is for residential tenants, not commercial tenants, so residential tenants in New York, in particular New York City, and it is current as of today, April 27th. I say that because this is going to be recorded and we don't know when things might be changing after today. To help you, if you have any questions during our webinar, we're going to have a Q&A session at the end. However, you're welcome to write questions in the chat as well as in the Q&A session. We can look at those after, or if it's something quick that is relevant to what we're just presenting on, we might address it as we go along. For today's webinar, we have three main objectives. The first one is we're going to be explaining tenants' rights pertaining to evictions, illegal lockouts, emergency repairs, and what protections are available to tenants during COVID-19. We're also going to provide an overview of what other resources and tools are available for tenants who cannot pay their rent during this time, and what they could expect if they get sued by a landlord in the future. And finally, we're going to address other housing related issues such as breaking the lease or other questions that might be posed during our Q&A session. So let's get started. We're going to get started with the number one concern for people is eviction. So we're going to discuss the protections against eviction for residential tenants. Governor Cuomo ordered a statewide suspension of all evictions last month, and that does include commercial and residential tenants, and that lasts until at least June 18, 2020. This is commonly referred to as the eviction moratorium. I say at least June 18, 2020 because there's a possibility that it might get extended, but as of now it has not. There are currently no exceptions to this order. So what does that mean? It means that you are protected even if you don't have a lease, even if you are in a market rate apartment or rent stabilized apartment. It does not matter. This protection also covers you. Even if you were subject to you have received an eviction warrant or you had an eviction schedule, at this time the marshal cannot evict you. So what happens if a marshal tries to evict you? You can call the Department of Investigation Bureau of the City Marshals. I'll put the phone number in the chat, but the number is 212-825-5953. For those who have an existing housing case, the housing courts are adjourning all of these cases, and you receive a small postcard in the mail with the new court date. If you already have an attorney, your attorney will be reaching out to you to inform you when your new court date is and what the next steps are. And if you have not heard back from your attorney, you could always call them. So I'm going to turn this now to Magda to discuss what's called illegal lockouts or self-help evictions.
Thanks, Edda. So illegal lockouts are pretty much exactly what it means. It means that a landlord or whoever you are renting an apartment or a room from has illegally locked you out of the apartment, has taken possession away from you from that apartment. As Edda said, there is currently a moratorium in the city and state of New York. That is illegal at this point. No one right now during this pandemic, at least through June 18th, and probably for some time after that, can be evicted. And an illegal lockout is an eviction. It is an eviction that happens by the landlord or whoever it is that you're renting from, as opposed to an eviction that happens through the court where there is a marshal involved. In New York, actually, in the city of New York, in the state of New York, there are, in order for someone to be evicted, they have to be someone who's lived in an apartment or in a room for 30 days or more. They actually have to be brought to court. A landlord, neither a landlord nor anyone else that you're renting from can decide on their own that they don't want you anymore in the apartment and lock you out. During this time, also as Edda mentioned, Should that happen to you, should you be locked out of your apartment, should you be locked out of a room that you're renting from, right now that is completely illegal and you have rights. If that happens, as Edda mentioned, you can, there are places that you can call, but there's two things that you should do. The first thing is you should contact the police. If you've been locked out of your apartment, right now the police will, if you can show that you actually live in the apartment, you'll have to show a letter, some ID that has the address. You'll just have to show that you live there. But as long as you can show that you've lived there, the police will probably put you back into the apartment. The other thing that you can do is, despite the fact, and we'll talk about this a little bit later, that the courts right now are closed for everything but emergency situations, an illegal lockout is an emergency situation. It is a situation that can affect not just your safety, but obviously your health during this period. It is considered an emergency, and you can go to the court, or you can ask the court to order your landlord or whoever it is that you're renting from to put you back into your apartment or your room. To file something in court, we can talk about that a little bit later. You don't have to physically go to the court. There are now ways for you to do that through email and through phone. I just wanted to end that. The important thing is that people know that they cannot be locked out, that if they have a place to live, they have that place to live at least until June. So go ahead.
Thank you, Magda. So now we've explained the eviction moratorium and how it protects tenants. So we're going to spend some time on what the limitations of the moratorium are and what to expect if you're unable to pay rent. So there are three things that an eviction moratorium cannot do, or does not do as of now. It does not cancel your rent, 1. 2, it does not suspend your rent. And 3, it does not prevent the landlord from seeking rent and sending you either a letter or calling you demanding that the rent do be paid. So what does this mean? This means that even though the landlord cannot evict you, the rent is still due. Technically, this also means that once the eviction moratorium expires, that all past rent will be due at that time, and the landlord can bring you to court for non-payment of rents. Now, I do want to take a moment to acknowledge that there are several proposals at the city, state, and even federal levels to address this issue, as most people who are struggling financially are not able to pay 3, 4, multiple months of rent at the same time. We won't discuss these proposals at this time, but it's good to just keep that on your radar. I encourage you to sign up for newsletters from your elected officials that usually keep their constituents informed as to any new legislation or proposals, and also to visit our website, which I included in the chat, so you can receive further updates. So since rent is still due, and many of our neighbors are facing financial hardship, especially here in Washington Heights and Inwood, let's focus on our tenants who cannot pay rent. So the first thing I want you to know is that you are not alone. Recent estimates show that nearly 1/3 of all renters across the United States were unable to pay April's rent when due. So there is no shame in this, okay? The second is that there are resources available to help you financially during these times. While the specific details of these resources are beyond the scope of this webinar, I want you to be aware of the following. One is that you may be entitled to a one-time stimulus payment, which you might have heard in the news, and it can range anywhere to at least $1,200 if your income is below $75,000, plus $500 for each qualifying child. Again, the specifics, it's a little bit more nuanced, but it goes beyond the scope of this webinar. Second thing is that the unemployment benefits have been expanded. So now the duration and the amount that you might qualify under unemployment benefits has increased through the Federal CARES Act, at least through the end of July. So that's something too. And I know that a lot of people are struggling with applying for unemployment and it's been very burdensome. but that is a benefit, a resource that can assist you during this time. And finally, there's public assistance, which you could apply, I believe, even online for SNAP, cash assistance, and there's rent subsidies, including FEPS programs. Again, we're not going to go into all the details, but you can reach out to the legal aid. We do have public benefits team that could assist you navigating those different resources. Finally, recipients of Section 8 subsidies and those renters, tenants who are living in NYCHA housing, you can have your tenant share recalculated to reflect the loss of income. So those are all resources that you should explore when you're trying to address your current loss of income. Now, of course, I understand that even with these resources, you might still be struggling to pay rent. And just to put into perspective, before COVID-19 struck our city, at least half of all renters were considered rent burden, and half of those were considered severely burdened, which means that more than half of their income went to pay rent. So obviously this is a struggle even before the pandemic hit. So if you're unable to pay rent, these are 4 things to keep in mind. As we have discussed, and we will continue mentioning it, you cannot be evicted at this time. Thanks to the eviction moratorium, which again protects you until at least June 18. The courts, as we mentioned, are currently closed for non-essential services, which means that the landlord is unable to start an eviction proceeding against you. Even once the eviction moratorium is lifted or the courts begin to accept new cases, a landlord has to follow a process that takes time. And to further illustrate this, I want to give you an example of what happens if you are sued for non-payment. A landlord has to serve you what is known as a rent demand. After 14 days, they'll file a notice of petition and a petition. They still have to serve you in accordance with the law. Once you are served, you have an additional 10 days to file an answer. And so again, I want to illustrate the amount of time that's passing, things that don't happen overnight. Once you file an answer, you will be given a court date to return. On that return date, you might have an opportunity to speak to an attorney. So this is related to the universal access to counsel. Many of you know that New York City is still rolling out what is known as universal access to counsel to give tenants legal representation. And it's going by zip code and also by income. Right now, zip code 10034, which is part of Inwood, if you live in this zip code, you are entitled to receive legal advice. Now, based on your income, you might also be entitled to full legal representation. But at a minimum, you could at least speak to someone in housing court. So that's another layer of protection that you have, even if after the eviction moratorium ends. And what happens even if you're represented by an attorney or you have to do it pro se? Most non-payment cases are resolved through agreements or stipulations and do not result in evictions. Many tenants are able to secure assistance through HRA and charities to cover some or all rent arrears. So in sum, I want to highlight that this takes time, that it hopefully buys you time to either find additional sources of income, to find assistance, and that you are not going to be evicted overnight just because the eviction moratorium is lifted. So I hope that provides some sort of comfort, also knowing that you're not alone, and that of course many of our legislators are aware of the struggles that our community is facing, and they're trying to find ways to address this in the legislation. So now I want to give Magda an opportunity to talk about one of those emergency cases where the housing court could help you if you're facing other issues.
Okay, so we've stressed, because we think it's so important for people to know that they cannot be evicted at this time and that they should stay placed, they should stay in their homes as the CDC and all the health professionals have been recommending. But for a lot of people, staying in your home isn't necessarily it's not always a safe place, it's not always a healthy place. And so we also want you to know that to the extent that you need services and repairs in your apartment or in your room that are causing a concern to your health or your safety, that is considered an emergency case which the courts will hear at this time. So emergency cases, we just got a couple of them today, actually. A lot of them these days have to do with people having no gas, having no heat, because despite the fact that it's almost May, it has been kind of chilly, having no hot water, having cascading leaks, rodents in the apartment or other types of vermin. If it's a condition that can affect your safety or your health, it's probably going to be an emergency condition, and you will be able to get redress from the court. And what that looks like is, I mentioned earlier that the courts are accepting certain cases, such as illegal lockouts. Emergency repairs is another one of those cases that the courts are accepting at this time. So if you have a condition, you can either go to the court in your borough. In Manhattan, it's at, where are we now? I think we're still at 111 Center Street. So you can go there to file a case. It's called an HP case, a housing part case. And it's a case just to get an order for your landlord to make repairs and provide services. Also included in that can be if you're being harassed. So if you feel that your landlord or who you're renting from is harassing you with the intent to get you to leave, then you can also bring a harassment case. And we've seen an increase in that, especially where people are concerned about tenants or other people in the building being exposed to COVID, having corona. That's a type of discrimination that is illegal. And it can be a form of harassment, and you can get redress. So you would file a case in court. Again, you can do it personally by going to court. You can also do it online. And all of this information, by the way, of how to do this is available on our website, which we'll put up on the chat. We have a lot of information and a lot of step-by-step instructions on how to file these cases. The other thing that I wanted to mention is that when you file these emergency cases, everyone now, regardless of income and regardless of zip code, is being assigned an attorney if they want. So if you've been illegally locked out, if you've been evicted during this period when you should not have been, if you have emergency conditions, or if you're being harassed by your landlord, once you file that case, you will be assigned an attorney. And if you want an attorney will be appointed to represent you in that housing case. You don't have to have one if you don't want one, but we are available to represent. And again, for this period, it does not matter your income, it does not matter your zip code. Everyone will be assigned an attorney. Edda?
Yes, thank you, Magda. We are getting some questions in the chat, and we're almost done with the main part of the presentation. So we'll be addressing those questions shortly, but thank you for those very good questions. The final big topic we're going to talk about is breaking your lease. So what happens? Sometimes perhaps you're unable to pay your rent. You're thinking maybe I'll just move in with family, go somewhere else, either for health reasons or just trying to save money. And you want to do so before the expiration of your lease. Well, vacating before the term of the lease is what we're considered as breaking the lease, but that can still leave you with a financial liability. So before you make that decision, you want to, of course, consult with an attorney. But in the meantime, here are some important highlights or things to consider. One, again, we stress you cannot be evicted at this time, even if you're unable to pay rent. So don't feel pressure to break the lease or have to move out because you're unable to pay the rent, because you are protected. Second, if you still decide that breaking the lease makes sense in your situation, it's a good idea to discuss this with the landlord and try to work out an agreement that possibly waiving whatever rent is still due, just working out something. There are times where you might be entitled to break the lease. So for instance, if you're a senior, 62 years or older, unable to live independently, and you're going to be moving in with a family member or into an assisted living facility, you're entitled to break the lease. If you are a survivor of domestic violence and you have an order of protection, you are also entitled to break the lease. So these are just two examples. So what happens if you break the lease? A landlord may sue a tenant for breaking the lease and seek to recover a money judgment for any rent due and other fees. However, remember, at this time, the courts are only accepting emergency cases for filing. So breaking the lease is not considered an emergency case. So at this moment, the landlord cannot sue you. But even if the landlord can sue you later on, once the courts open, and they could seek money damages, the law requires that the landlord mitigate or reduces its losses by trying to rent out the apartment at a market rate or at least something equal or about the same amount as your rent. So now this concludes the presentation portion of our webinar. We hope you found this information helpful, and at this time we want to give you the opportunity to ask questions. We know we have a few ready in the chat, so we'll address these questions and make it a little bit more interactive.
So I just want to address the question about status. Status is not an issue. At this point, when you are referred to an attorney, for the Legal Aid Society, I just want to make this point clear. For the Legal Aid Society, status is never an issue. We will represent tenants that are eligible for our services regardless of their immigration status. So in order to qualify for services normally, in regular situation, you would just have to be a low-income New Yorker. Right now, we're accepting cases from any New Yorker that has a need, and immigration status does not come into play whatsoever.
Magda, there's a question here. I'm gonna take the one about the late fees because I think that one's a little more straightforward, and then maybe we could address the one about the rent strike that Lena Melendez asked. So the question is, can the landlord charge late fees for unpaid rent during the eviction moratorium? Would those also be due June 18? Magda can correct me if I'm wrong, but I believe that late fees can still be charged. However, late fees, so a landlord can sue you in housing court for unpaid rent. And again, assuming that nothing changes with the law, that we just have the current status of an eviction moratorium. Once that expires, unless it's extended or anything changes, the rent is due and there will also be late fees. However, the landlord cannot collect the late fees in housing court. You cannot be evicted because of late fees. They could only collect rent. So they could collect a money judgment. They could try to sue you in small claims for late fees, but they cannot collect that in housing. Tom, I hope that answers your question, but Magda, do you have something to add to that?
Yeah, I did want to add that to keep in mind that things are changing during this pandemic day to day. And while Edda is correct that that is the state of the law at this moment, you should know that certainly the Legal Aid Society, community organizers, tenant advocates, elected officials, there are a myriad of people and organizations that are working to help people when we come out of this pandemic. And one of the things that people are looking at is how will people be able to pay rent, including late fees? So just because that is the state of the law right now does not mean that that will be the state of the law tomorrow, next week, next month, or whenever Corona is finally resolved.
Magda, can we, Lena has to sign off in a little bit. She was the first question. Do you see her question about the, okay. Maybe you want to read it all out so everyone knows?
Sure. The question is, those of us who are joining tenants unable to pay rent in solidarity, but who will be saving our rent money, what jeopardy are we in? And this again goes to Edda, what Edda said in terms of what is the state of the law right now versus what could potentially be the law in the future. Right now, for tenants that do not pay their rent, when this pandemic is over, if the law does not change, they will be subject to eviction. The landlords will be able to sue them. They will have to go to court. They'll have to prove that, the landlord will have to prove that money is owed. They'll have to prove the amount of money that's owed. And to the extent that the tenant has a defense to that money, the defense could be that the apartment was not habitable, that it wasn't safe, that it wasn't decent, that the rent was illegal. There are any number of defenses that tenants can raise. To the extent that tenants can raise those defenses, they can and they should. And at the end of the day, a judge will decide how much money is going to be due to the landlord. Now, that is again assuming that the law hasn't changed. If you have the money and you've put it aside, which is what a rent strike is, I also want to be clear about that. A rent strike, like any other strike, is a knowing and voluntary decision that people make to stop doing something. So just like a food strike or a hunger strike, people stop eating food that they have. In a rent strike, you stop giving the landlord rent, but that doesn't mean that you spend it. It means that you put it aside. It just means that you're not giving it to the landlord. So to the extent that you are in solidarity and you have the money, if the landlord sues you, then you have the money and you'll be able to pay it and you will no longer be subject to eviction. The issue comes in if you don't have the money, if you didn't save it when you had it, and then we go back to what I said before. The landlord has to sue you, they have to prove their case, you can raise your defenses, and at the end of the day, if the judge determines that you owe an amount of money that you do not have, you will be, or you can be subject to eviction.
Thank you, Magda. I have a question from Edda Alfonso. It says, what would you do if your lease has expired in 2018 and now your landlord wants you to sign a new lease and they are aware that you lost most of your income? I am assuming this is not a rent stabilized apartment, I imagine. Edda, Magda, what would you say? I mean, if they want you to sign a new lease,
So again, you're right. It does depend on the status of the tenancy. So if it's a rent regulated status, you automatically get a lease.
Right.
And to the extent that you think right now, people's concern should be their health and their safety. And then you can deal with money issues. That's a secondary type of issue. If you think that you want to stay where you are, and regardless of whether or not you think you'll be able to pay for it, if you think that you want to stay where you are, then you should probably renew a lease. And this is especially more for rent-regulated tenants than it is for market rate tenants. And then you should try to figure out how you are going to comply with that lease in terms of the payment. How are you going to, between now and whenever a situation arises, how are you going to make those payments? And you can fall back to the things that Edda said in terms of the different benefits that are available, the stimulus package, maybe people will have jobs by then. You can also try to negotiate, and this is something that everybody can do, especially right now. One of the most important things that you can do is to negotiate with your landlord. This is a little bit harder if you don't have a good relationship with your landlord, but this might be a time to establish a better relationship. So you can talk to your landlord and say, look, because the world knows that we are all going through this particular situation. We've lost our jobs, we've lost our steady forms of income, but we've been good tenants, and we want to do right by you as well as by us. So let's try to see what kind of deal we can reach. Maybe we can, throughout the period that you're unemployed or your income has been diminished, maybe you can make a plan with the landlord that you'll pay a lesser amount. Maybe you'll pay a lesser amount when your new lease starts, and then it'll go up to the regular rate incrementally or over time. This is a good time to talk about those kinds of issues. And you can reach out to the Legal Aid Society and other legal aid providers to find out what other kinds of things you can negotiate. I did want to mention though that in terms of negotiation, it is usually better to negotiate with your landlord if you have a group of tenants, if you've actually formed a tenant association and you're working together for the benefit of the members of that tenant association. The unit that I am the director of actually exclusively represents tenant associations. And so to the extent that you need information about forming a tenant association and what kinds of things a tenant association can do, you should feel free to reach out to us. I hope that answered the question.
I think so. in her case, it's a private home, so I mean, there's more flexibility, I think, to negotiate with the landlord. And if there's no lease, Magda, isn't it then, aren't you on a month-to-month tenancy at that point? So there is usually beneficial to the tenant to kind of have a lease, even if it's a shorter term lease. There were a few questions. A follow-up question to the rent strike, and I think you answered this. The question, I believe, was from Bruce. In a rent strike, is it important to put the rent into an escrow account to show it's available? And I think that's typical for rent strikes, right, Magda?
That is one of the things that you can do. An escrow account, for those that are unaware, is an account held by an attorney where they hold on to monies that their clients want them to hold on to, usually because there's a dispute about who the money should go to. But you don't necessarily have to put, you can have a rent strike and not necessarily put rents into an escrow account. If you have a tenant association, and this is something that we recommend to our groups all the time, as a tenant association, it might be a little bit more difficult right now, but as a tenant association, you can open up a tenant association account, and the members of the tenant association can deposit their monies into that account. That entails some of the tenants taking on a lot of responsibility because somebody has to be monitoring the money that's coming in, making sure that people get receipts, and keeping an accounting of that sum. That's usually something that's done by an attorney if you have an escrow, but you don't necessarily need to have an escrow. There are times where people just keep the money in the bank, in their own bank account, and they just show their bank statements or the deposit slips to show that the money is available. It's also something that can be done. The reason why we recommend usually for people to put money in the escrow account is because, especially in these times where the financial situation of a lot of our clients and a lot of the city is under such dire circumstances, to put the money in an escrow account gives you a measure of safety. It's not as easy to get the money out of the escrow account if you want to go, buy whatever it is you want to buy or spend it. It gives you that measure of safety. That's why an escrow account is recommended, but there are other ways of doing it.
A question from Aisha. We mentioned something about tenants being able to break a lease if they're entering into an assisted living facility. So if a tenant's entering a nursing home, let's say mid-lease, but has an eligible member who has succession rights, is there any problem with them transferring the lease to the family member?
Succession rights, again, for those that aren't familiar, only apply to rent-regulated tenants. So you either have to be rent-controlled or rent-stabilized. Generally, rent-controlled are tenants that have been living in the apartment since 1974, I believe. Don't quote me on that because it could be 1972. And rent-stabilized tenants are tenants that live in buildings that have 6 or more units and were built after 1970 something. Those tenants who are rent-regulated, who are either rent-controlled or rent-stabilized, have succession rights, meaning that once the name tenant, the tenant of record, vacates the apartment or gives up their rights to the apartment, an eligible family member can then claim tenancy rights to that apartment. Your succession rights are succession rights. It doesn't matter. What needs to happen for succession is that the tenant of record permanently vacates or gives up their rights, and there is an eligible family member that can come in. To be an eligible family member, the law says there's categories. You have to be a child, a parent, a spouse, a niece, a nephew, a grandparent. Those are people that can have succession rights if they lived with the tenant of record for 2 years before the tenant of record left the apartment or gave up their rights to the apartment. 1 year if the person that's claiming succession is a senior citizen or is disabled. So once you have succession rights, you have succession rights. It doesn't matter whether it's in the middle of the lease, whether it's at the end of the lease. The succession rights will attach whenever the person gives up the right to the apartment and somebody is eligible to succeed.
So speaking of breaking leases, one of the questions had to do with one of the topics you covered, Magda, emergency repairs. So it says, does the lack of emergency repairs entitle someone to break their lease? Related to that, if a tenant gets an order, we talked about tenants being able to get an order for emergency repairs, but let's say the landlord ignores that, how can a tenant get that order enforced?
So to the first part, whether or not, if the landlord does not do emergency repair, whether that's grounds for breaking your lease, typically it isn't. There are a number of attorneys now who are thinking of different challenges to the law to make it more expansive so that it will include more things. But typically, the fact that your landlord has not provided repairs and services will not give you a right to break your lease, especially if you never did anything about the conditions. If you never told the landlord, you didn't try to bring an HP, those are typically not going to be grounds. They're not grounds right now that are accepted as a reason to break a lease. The second part of the question, Edda, was?
What if you already have an order and the landlord is just refusing to actually make the repairs? How can you get that order enforced?
That is very difficult at this time, unfortunately. It was hard before, but it was certainly a lot easier than it is right now. And the reason why it's hard right now is because some landlords are saying that their workers do not want to go into buildings where they don't know that the health status of the people, the residents of the building. And conversely, there are a lot of tenants who don't want workers in their apartment right now because they also are concerned about what these workers could be bringing into their apartments. The typical way of enforcing an order to correct is to go back to court and hold the landlord in contempt. And contempt is a word where somebody doesn't comply with a court order. In terms of the landlord, contempt will usually mean three things. One, they will be ordered again to do the repairs. They can be issued a fine, or they can be jailed for not doing the repairs. We have not found right now, we've actually been quite lucky because the cases that we've seen, the landlords have been willing to go in and do work as long as the tenants allow access to do work. And we haven't had a lot of cases where we've had to bring contempt motions. We do have one pending. I don't know how it will turn out. We have a contempt motion pending because the landlord just hasn't done what they were supposed to do. And again, are claiming that they can't get anybody to actually go in and do the work because people are concerned about going into other people's homes at this point.
Magda, that's great. You actually answered another question that someone had about workers bringing, being exposed and coming to the home. So Aisha, I'm going to skip your question because I think it was already addressed. I'm going to take Yolani's question that she asked, what if you receive a 14-day notice or have a pending case with a date to go to court? I'll answer that. A 14-day notice is the rent demand that predates the petition and the notice of petition. If you receive that, that means unless you get the petition that a case has not even been filed yet, and at this time, landlords just can't file new cases. If you have a pending case with a date to go to court, you should have received a postcard with the new date because all the cases are being adjourned. If you have not, there's two things. So if you have an attorney, reach out to your attorney. If not, you could contact the housing court, right, Magda? They could just call is it the phone number or do they have to email? I think they could just call, right?
There is a number. It is answered sporadically because again, everybody's working remotely. You're safer using the email.
Yeah, I mean, right now, just to give you an idea, pretty much all my cases have been adjourned to June. And I think that's what we're going to be expecting. Then
they'll probably be adjourned again.
Yeah, and
Um,
we okay, so we got a few more questions about extending eviction moratorium, putting pressure, and how do we do this? I love that. It shows that people in this webinar are very engaged in their communities and they want to do something, be proactive. I agree with Bruce. Bruce mentioned maybe calling your elected officials, putting some pressure. You know, following some. There are several groups in our community that are very active, especially in housing. I mean, you probably heard of Met Council. There's Northern Manhattan's Not for Sale, Housing Justice for All. There's several in our community that are very active in this issue. So if that's something you're interested in, you should reach out to them and go to their meetings, find out what sort of efforts they're leading to put pressure. Okay, so we're going back to rent strike. That seems to be a big topic. So Alexandra asks, if doing a rent strike, would one need to budget both for rent and late fees? Um, Magda, as the law is right now, would say yes as of now. How would you address that?
That's a good question. I've done a lot of rent strikes in my time, and we've never paid late fees. But the thing about rent strikes is this: one, it's a group effort. It definitely takes more than one person, and two, it's a negotiation. So pretty much at the end of that negotiation, I would say like 99% of the time, you're going to be able to negotiate with the landlord to do what it is that you started the rent strike for. And historically and traditionally, rent strikes have been started because of conditions in apartments or in buildings, or because there's been some other breach of the lease that the landlord isn't, or the law that the landlord isn't complying with. And so there's a lot of negotiation that happens with rent strikes, but usually I would say like 95 to 99% of the time, the negotiation results in the tenants getting some of what they want, and the landlord getting some of the money that was withheld.
Okay, so there's one question
Without fees, without fees, by the way. And there are a lot of other things that can happen in a rent strike. It's not just about who gets the money, or whether or not they do repairs. We've had rent strikes where tenants have gotten community rooms. We've had rent strikes where tenancies were recognized. The landlord accepted that certain tenants were actually going to be the legal tenants of the apartment. We've had rent strikes where the rents have been corrected, and the landlord is now charging a legal rent. Or we've had rent strikes where tenants get extended abatements, which is a reduction in the amount of rent.
Okay, so we have a few more questions, and I know we're coming to the 6 o'clock time, so I want to be conscientious of people's time. There's a really good question here about distinguishing between what a rent suspension, rent cancellation, and rent freeze means. And these terms are used a lot right now in housing advocacy, so I could understand why it could be a little confusing. For me, rent suspension means that you're not, well, Magda, maybe you could give a very succinct explanation as to rent suspension, rent cancellation, and rent freeze.
Okay, rent cancellation, the rent is canceled, you don't owe it, excuse me. You don't owe it now, you don't owe it later, it's done, it's over, that's it. Rent suspension is you don't have to pay it now, but you will have to pay it later, probably at some point. Rent freeze, again, applies to rent-regulated tenants, and it's a freeze in the amount of the increase that a landlord can take when your lease is renewed. That's as succinct as I can put it.
And just to put this on people's radar, there might be, if you are disabled or if you're a senior citizen, there are programs to freeze your rent for rent-regulated apartments, SCREE and DREE. Again, that's beyond the scope of this webinar, but you can contact our offices or go to our website to learn more about that, because that's another way of managing, the rent burden. There were a few questions about repairs. Let's see. Is it fair to deduct pay from your rent if the management did not provide heat for the month? HP was involved, they were fined, but heat is included in our rent. So that's a question from Trina Vargas. Is it fair to deduct pay from your rent? So withholding a portion of the rent if management did not provide heat for the month. HP was involved, I guess HPD was involved and they were fine, but heat is included in our rent. I get it. So the landlord was fine, but that didn't necessarily help you, Trina, right? Like you still have to pay the same amount of rent and that includes the heat. That's my understanding of the question. Yes, she said exactly.
So there, I guess this kind of goes back to, it's a rent withholding. So when you rent an apartment, when you have a lease, that's a contract. So your responsibility under that contract, the tenant's responsibility under that contract is to pay rent and to keep the apartment in semi, it's not your apartment, it's not the tenant's responsibility to repair the apartment, but to keep it in fairly good condition. The landlord's responsibility, though, is to provide services and repairs, including anything that is needed. When one of those parties does not comply with their obligations, then the other party has remedies. So if the tenant doesn't comply with their obligation to pay rent, the landlord's remedy is to take them to court. And paying rent means paying whatever the full rent is, whatever the full legal rent is. If you don't pay that, the landlord's remedy is to take you to court to try to evict you. By the same token, if the landlord doesn't comply with their obligations in terms of providing services and repairs, then the tenants have remedies. And one of those remedies is they can withhold rent. You can never, it's not a deduction. You can't on your own decide that you are going to deduct this amount of money because the landlord didn't comply with their obligation. You can withhold it, and then either you can take the landlord to court, or when the landlord takes you to court because you didn't pay the rent, a judge then will decide how much you can deduct from your rent. That's called an abatement, which I mentioned earlier, but it's not, tenants on their own cannot self-help in that regard. You can't decide on your own that you're going to deduct X amount of money from the rent because the landlord is not complying with your obligation. Either you reach an agreement with your landlord about that, or a court has to decide on.
Okay, so we only have 4 minutes left, and so we have to wrap this up. However, there are a few other questions. Lena, I think you have my personal email address, so if we don't get to yours because you had additional follow-ups about rent strike, you can follow up with me and we'll talk about it. I'll put you in connection with Magda, just because I want to give the opportunity to others to address other people's questions. Jeannie had a few questions. One of them is, if there's no gas, will the DOB take care of it? Tenants without gas for 1 year.
DOB?
Is it Department of Buildings?
Yeah, I know, Department of Buildings. If there's no gas in Manhattan, that's usually a Con Ed issue. DOB will be involved usually when we bring those HP proceedings, which we mentioned earlier, which is a proceeding where the tenants sue the landlord to get repairs and services. We also sue the Department of Buildings and Con Edison because all of them together are responsible for getting the gas on. Again, all of this is a little bit, I shouldn't say a little bit, all of this is harder to do right now because of the coronavirus. Because of the self-distancing, because of the health concerns that people are raising. But if, Jeannie, refer that case to us,
Yes, I included my email address here. So if you want to follow up, you can send me an email. Magda and I will connect about it so we could give you a little bit more detailed response because we're basically at the end of our presentation. Unfortunately, we don't have any more time to answer any more questions. So there's my email address. You're welcome to follow up with us.
I just want to mention this one thing because I see the question here and I don't know where it is, but in terms of safety, if you're having someone come into your apartment to do repairs, you can absolutely request that the landlord provide masks and gloves and sanitizing equipment for the workers, as well as for whatever they're going to be touching in your apartment.
And
You
Dorian,
can and you should.
I think we have to, we're
Yeah.
almost at the end.
Yeah.
We're almost at the end. And I just want to thank you both for incredible presentation. It was very powerful, very informative, and also hopeful. I would say it gives you hope and gives our community hope that they will be represented by such a great organization. So I want to thank Magda and Edda, and please, for everybody who would love to reach out for the Y services, please reach out back again. It's especially if you are a single parent who is struggling with loss of a job and struggling with rent. There are some charities, as was mentioned in the webinar, that there are people who are interested to help our community. The Y has been here for 103 years, and we will stay here for you to support you and provide you with all the necessary information, and as well help and some fun. So visit us at the Y, and thank you very much to all who participated in this webinar.
thank you very much. Thank you. Have a great evening.
Good night, everybody. Best of luck.
Bye.
Bye-bye.
Bye.